At the time of the offending, you were 29 years old and unemployed. However, you have previously worked as a housemaker. At the time of the collision, you were the holder of a disqualified Victorian probationary license. The deceased Mr. Trover was 31 years old and worked as a subcontractor with his brother. You were in a de facto relationship and resided with Miss Stephanie Dunlop in Newcombe, Victoria. You knew Mr. Trover had previously been close friends. However, there had been a breakdown in your relationship after Miss Dunlop and Mr. Trover had an affair in 2022 while you were serving in a period of imprisonment. This breakdown is apparent in some text messages exchanges between you and Mr. Trover in August 2022. On Monday, 11 December 2023, you were driving a Holden and Miss Dunlop was sitting in the front seat as a passenger. The Holden was owned by you, but you had not transferred the vehicle registration details into your name. At approximately 6:42 p.m., you turned onto the street of collision, which was a regular deviation from your usual route home, in the hope that you would encounter Mr. Trover. Miss Dunlop told you not to turn onto the street as she knew that you intended to confront Mr. Trover. At approximately 6:42 p.m., you turned onto the street of the collision, which was a regular deviation from your usual route. I think I'm repeating this, sorry. At approximately the same time, Mr. Trover left his house to visit a friend. Mr. Trover was riding a Segway 9-bot electric scooter. The scooter had a top speed of 25 kilometers per hour. You slowed as you passed Mr. Trover's house. Miss Dunlop said to you, "Don't be an idiot, just keep driving." You and Miss Dunlop then observed Mr. Trover riding a scooter down the street. You then said, "That's Bryce, I should get out and hit him." Miss Dunlop then replied, "Don't be effing stupid." Driving the vehicle, you caught up to Mr. Trover and intentionally maneuvered towards Mr. Trover and yelled out to him. At approximately 6:43 p.m., you swerved the vehicle and intentionally hit Mr. Trover from behind while traveling at approximately 45 kilometers an hour, inflicting fatal injuries. The impact of the collision caused Mr. Trover to travel up over the bonnet of the Holden and impact the windscreen, causing it to shatter. Mr. Trover was then thrown up into the air after he landed on the road, where he then skidded approximately 7 meters. After colliding with Mr. Trover, you failed to stop and drove away at a fast rate of speed. Residents from the nearby house heard the collision and attended Mr. Trover on the roadway. He was unresponsive. Emergency services were called and attempted to resuscitate Mr. Trover. He was declared dead at the scene. The collision occurred on Mr. Trover's residential street approximately 400 meters from his home. On 18 December 2023, Mr. Trover was examined at the Melbourne Coroner's Court by forensic pathologist Dr. Michael Duffy. Dr. Duffy determined the cause of death to be head injuries sustained in a motor vehicle incident. And Dr. Duffy further said autopsy findings indicate he sustained high-energy impacts to his head, torso, and pelvis, which are inconsistent with a simple fall from an e-scooter alone. The band-like soft tissue hemorrhage across the lower back indicates he sustained a high-energy impact with a broad surface. Impact from a bumper of a vehicle is the most likely cause for this injury. He was approximately 103 centimeters from the heel, not incorporating the height of the electric scooter. These findings are highly suggestive that he was struck by a vehicle. On 29 July 2024, a reconstruction expert, a police detective from the Collision Reconstruction Unit, provided a statement in relation to the collision that Mr. Trover was impacted at 45 kilometers an hour, as stated by you as in the accused, and I, as in his or her honor, will return to that. The victim would have traveled about 11.39 meters post-impact. The expert further said that Mr. Trover was upright at the time of the collision and would not have been hit if the vehicle had not swerved in his direction. Mr. Bench, this is the name of the accused. The cold hard fact is you struck Mr. Trover's person directly and intentionally with your moving vehicle. Following the collision, you drove the Holden to an unknown location where you left it until after sunset. Later that evening, you returned to the Holden and drove it back to your residence where you parked it in the garage. The next day, on 12 December 2022, you, along with the assistance of Mr. Jack Mawson, removed parts from the vehicle to prevent it from being identified. Mr. Mawson's wife refused to store the vehicle at her house. You and Mr. Mawson then stored the vehicle in an unused garage of a friend who had no knowledge of the offending. In the period after the collision, you and Ms. Dunlop also reset your mobile phones. You began using a new mobile number. On 19 December 2023, police attended your address and obtained a written statement from you. In this statement, you said that you had bought the Holden, but then had sold the vehicle to a man you did not know but was named Jason Hart. You produced handwritten receipts relating to the purchase and sale of the vehicle. The receipts indicated that the Holden had been sold to Jason Hart on 1st November 2023, that is 10 days prior to the collision. The police investigated Mr. Hart and discovered that he had passed away on 13th of November 2023. The police in the investigation identified you as driving the vehicle from CCTV footage. A witness who attended the police and reported that he had seen a Holden collide with Mr. Trover and by cell tower location mapping. CCTV was footage collected from the street of the collision. In the CCTV camera from Mr. Trover's residence, Mr. Trover is seen leaving his residence on his scooter. Some 25 seconds later, you are captured in the same CCTV footage, driving the Holden with Ms. Dunlap as a passenger. Other CCTV footage in the street shows you following a few seconds behind Mr. Trover. Further CCTV footage captures the sound of the collision. On 3rd March 2024, police intercepted a call between Ms. Dunlap and her niece, having obtained telecommunications interception warrants. In the call, the niece talked about Ms. Dunlap riding an e-scooter and stated, "Don't be like Bryce and die." Ms. Dunlap replied, "Oh my God, LOL, I probably won't fall as hard." On 6 March 2024, you received a phone call from Mr. Mawson. During the call, you and Mr. Mawson joked about a person falling off a scooter by saying he had done a Bryce. You also said to Mr. Mawson that you had said to Ms. Dunlap, "If I get done, I was just like you're getting done as an accomplice. So you're just doing half as long as I do." On 2nd April 2024, the Holden was located in the address in Whittington, Victoria. Parts had been removed from the vehicle, which included the windscreen, front bumper bar, ladder racks, removable sides from the metal tray, the toolbox from the rear tray, and the wind plates. Upon locating the Holden, the police seized the vehicle. On 19th April 2024, you told Mr. Mawson and your associates who had hidden the car that as soon as fingers started being pointed, that you would put your hand up for everything. On 20th May 2024, major car crash collision officers attended Mr. Mawson's residence. At approximately 2:11 p.m., Mr. Mawson called you and told you that you had 1 hour to hand yourself into the police because she wasn't losing her kids over you. At approximately 3:46 p.m., you called your friend and told him that you were going to hand yourself in the police. Your friend replied that you would be the boss in prison because you had killed someone. On 23rd May 2024, you and Ms. Dunlap were arrested and various items were seized. You have been remanded since this date. On 23rd May 2024, you participated in a recorded interview with police. During the recorded interview, you stated that you were unaware of the identity of Mr. Trover at the time of the collision, that Mr. Trover had fallen in front of Holden, and the only reason you had fled the scene was because you were scared, as you did not have a license. The police then presented you with the evidence they had gathered. The interview was suspended to allow you to have a break. After the break in the interview, you then made admission. You admitted, and now I, as in his or her honor, now going to list some of the admissions you have made. A. You drove into the street hoping to come across Mr. Trover, and that you had recognized Mr. Trover when you saw him riding the scooter. B. That you were traveling at about 45 kilometers an hour at the time of the collision. C. That you wanted to assault Mr. Trover by punching him. D. That you had previously chased Mr. Trover on foot to assault him, however Mr. Trover rode away on scooter. E. You intended to knock Mr. Trover from his scooter. You said that you did this as you were aware from the previous interaction that if you stopped the Holden, Mr. Trover would again escape. And you stated, I was just trying to nudge him and it didn't go to plan. Yeah, by nudge him, you meant just intentionally bump him with the scooter. It was not your intention at all to hit him or kill him. G. When asked what you thought would happen if you nudged Mr. Trover, you said, like, I don't know, maybe just fall off the scooter and then I would be able to talk with him, like not die. You had heard rumors of Mr. Trover and Ms. Dunlap having a sexual relationship in 2021, but said that Mr. Trover had refused to tell you if the rumors were true, which upset you. You could not remember the maneuver you made to cause the nudge. You didn't accelerate. You may have turned. As a result of the impact, Mr. Trover hit the windscreen and fell off. You stated in your record of interview that you were remorseful as F, but didn't have the balls or decency to hand yourself in. I, as in his or her honor, turn now to assess the objectivized gravity of your offending. In my view, his or her honor's view, your manslaughter is a very serious example of the offense of manslaughter. There are a number of reasons why that is so. Firstly, you deliberately struck Mr. Trover with your motor vehicle with the intention of knocking him from his electric scooter. This was the agreed factual basis of the plea. It constitutes the unlawful act component of the offense of manslaughter by unlawful and dangerous act. Collisions involving motor vehicles and pedestrians or riders are often referred to as accidents. The collision with Mr. Trover was no accident. Here, your act in driving into Mr. Trover was intentional. As in his or her honor, have said, it is common ground that you fall to be sentenced upon that basis. Second, your unlawful act, deliberated striking Mr. Trover with your motor vehicle, was an extremely dangerous act. An act is dangerous if a reasonable person is in the position of the offender, would have realized he or she was exposing the victim to an appreciable risk to serious injury. This is an objective test. By your plea, you have accepted that this unlawful act was relatively and objectively dangerous. In assessing the gravity of your offense, I must make some assessment. I, as in his or her honor, must make some assessment of the level of dangerousness involved with this act. Mr. Trover was utterly vulnerable and exposed while riding the scooter. There was no protection between Mr. Trover's person and any impact from your motor vehicle. He was not wearing a helmet. The risk of serious injury was great. This was a very dangerous act, even if it was only your intention to nudge Mr. Trover. In any event, by your own admissions, you were traveling at some 45 kilometers an hour. As your counsel properly accepted during the plea, this was in fact a significant impact at speed. Even though you only intended to knock Mr. Trover off the e-scooter for the stated purpose of confronting and assaulting him, and that you did not intend this dreadful outcome, this is a very serious crime. Third, the gravity and indeed horror of this manslaughter is self-evident. Mr. Trover was thrown onto the bonnet of your vehicle, impacted with the vehicle's windscreen, and then skidded for several meters. Fourth, your actions are not explained in any way by the conduct of the deceased. Your actions were in no way responsive or reactive to anything Mr. Trover did on that day. Indeed, you had been searching for Mr. Trover with the intention of assaulting him for some time, apparently out of sense of jealousy. To that end, you drove into Mr. Trover's street on this occasion in the hope of locating him for that purpose. There are no extenuating circumstances which immediately surrounded this episode. Fifth, the offending was committed in a residential and public street. Members of the public were potentially exposed to witnessing this horrific event. Unsurprisingly, at least one saw it and others heard it, and rushed to Mr. Trover's aid, who was unresponsive on the roadway. They all witnessed this awful aftermath. Having regarded these matters, I accept the prosecution's characterizations of the objective gravity of this manslaughter as falling into the higher range of manslaughter offenses. Your culpability is very high. Of course, you also fall to be sentenced for the failure to stop after the collision. The prospect of Mr. Trover having sustained a significant injury must have been evident to you. You showed a callous and total disregard for his well-being and chose instead to act out of rank self-preservation. Your failure to stop was disgraceful. This was a serious example of this offense. You have a criminal history which began in 2014. However, you're not a person who has spent much time in prison. You have typically received orders for fines, community work, and disqualification from holding your driver's license from your previous convictions. Most notable from your criminal history is a conviction for an armed robbery offense. You were sentenced to a 15-month sentence with a non-parole period of 9 months. You were released from custody on parole in March 2022. You complied with all conditions of your parole, and I will return to that. In 2019, you also served a second, albeit brief, 2 days imprisonment sentence, which related to a number of offenses, including to threat to destroy damaged property. You have a number of priors for driving offenses, which range from driving with a disqualified license to driving at dangerous speeds and while exceeding the prescribed concentration of drugs. You also have multiple dispositions for drug-related offenses related to possessions of methamphetamine and GHB, as well as dishonesty offenses. You have not always complied with the orders made by the court. You have contravened a number of community correction orders and several interim personal safety intervention orders. In 2016, you failed to answer bail. You are now 31-year-old. You were born and raised in Geelong as an only child. Your father worked as a cleaner and maintenance worker at various schools and institutions, which he continues on a casual basis. At one point in time, your father retired to provide full-time care for your mother. Your mother suffered from muscular dystrophy and required assistance from you and your father with daily activities. Your mother passed away from a choking incident and other health complications in 2022. You completed schooling to year 10 and have prescribed some experience of being bullied. You left school to increase your gaming hours, where you would play Call of Duty in excess of 8 hours per day and watch television. Your grandmother passed away around the time you left school. You subsequently completed year 11 via other means. After your schooling, you commenced work as a painter without a formal apprenticeship. You worked as a contractor under your own business name and were employed by several companies as a painter. You were also a recipient of Centrelink income. You have had 2 serious romantic relationships, the most recent with Miss Dunlop for 6 years. You reported that Miss Dunlop was pregnant when you went into custody for these offenses and gave birth to your son in October 2024. And I will return to that family matter shortly. You reported that you had been sexually assaulted when you were 7 years old by the parent of a friend while you were visiting the house and bathing. You stated that you have never disclosed this even to your parents. You constantly relied upon various materials in relation to your mental health and substance abuse history, including a report of Dr. Carla Lechner, clinical psychologist, dated 19 February 2021, a Justice Health Service records authored by Dr. Delene Brookstein, senior clinical and forensic psychologist, dated 24 September 2025, who met with you and treated you multiple times during the period of your remand. A report of Dr. Matthew Stios, clinical neuropsychologist, dated 13 June 2025, followed by an addendum reported dated 5th November 2025. In the addendum reported, Dr. Stios incorporates and examines the Justice Health records concerning your psychological functioning while in custody. You variously reported that you had used substance daily since the age of 16, excluding periods of time spent in custody and brief period of abstinence. At around age 16, you were a regular user of multiple substances, including GHB, ecstasy, cannabis, cocaine, and methamphetamines. Your polysubstance abuse has led to hospitalization at times. On 5th September 2023, approximately 3 months before Mr. Trover's death, you were referred by Newcomb Central Medical Center to Drug and Alcohol Services in Geelong. The referral notes indicate that you had been able to wean yourself off some drugs and alcohol. You were, however, keen to get off the GHB but required assistance with this. Multiple attempts were made to contact you, but they were unsuccessful and your program was closed. You reported that you have abstained from drugs while in remand and have made attempts to rehabilitate. Miss Lechner, clinical psychologist, observed that you presented with symptoms of methamphetamine and GHB use. She was of the opinion that your problem with drug abuse were typically associated with your offending behavior. Mr. Lechner was of the opinion that you did not present with symptoms of an underlying psychological or psychiatric disorder. However, she was of the view that you were quite emotional and socially immature and prone to peer influence, particularly in group settings and whilst affected by drug. Dr. Steos, clinical neuropsychologist, observed that your drug use was best understood in the context of psychosocial vulnerability, trauma, and susceptibility to negative peer influences. Dr. Steos opined that your intellect fell within the average range overall and that your psychosocial history included exposure to bullying in your childhood and adolescence. Dr. Steos was of the view that it was within the context of being bullied that you appear to have commenced experimenting with substance. Dr. Steos also noted that you gravitated towards unstable, impersonal relationship leading to the perpetuation of drug seeking and addiction. Dr. Steers diagnosed you with generalized anxiety disorder, major depressive disorder, GHB use disorder, stimulant, in particular methamphetamine use disorder, and alcohol use disorder. Dr. Steers' opinion was that your records, and as I noted earlier, he examined the Justice Health records, depict chronic generalized anxiety disorder, complicated by substance dependence, poor adherence to antidepressant therapy, reluctance to engage in psychological treatment, and continued drug-seeking behavior for benzodiazepines. Forgive me for not saying that right. His functioning appears affected by anxiety symptoms and substance misuse, though he retains insight and denies suicidality. Your psychological background and drug abuse history are relevant to a number of matters which have been advanced by your counsel on your behalf at the plea hearing. I now turn to examine these mitigating factors. Your counsel submitted that your admission made in your interview with the police were of real benefit and facilitated the course of justice. He submitted your admission solidified the prosecution case and filled in some of the important detail. In particular, there was significant utility in your admission that you deliberately struck Mr. Trover and that you were driving at 45 kilometers an hour. While the prosecutor did not quibble with the general tenor of this submission, he emphasized that this was always a strong case for manslaughter based upon a deliberate striking. It was argued that a cogent inference of a deliberate striking could be drawn from the evidence of animosity between yourself and Mr. Trover. The fact that you were seeking him out in a car, the evidence that you were at least seeking an altercation, the CCTV footage, and your post-offense conduct. To be clear, your counsel did not suggest that your admission supplied investigators with the case necessary to obtain a conviction for manslaughter, or that the proof of the manslaughter charge depended entirely or substantially on your admissions. Indeed, your counsel explicitly said that he would rely upon asking for a Doran discount. So understood. I do not think there was much distance between the position advanced on your behalf and the advance by the prosecution. I generally accept the submission made on your behalf that when you did finally make admissions after the break in the interview, they were of real value and did advance the course of justice. You deserve credit for this. It was submitted on your behalf that your plea of guilty was of utilitarian benefit and demonstrates your willingness to facilitate the course of justice, and that accordingly you are entitled to a significant discount. There was some discussion at the plea about what flows from the fact that the plea has only been entered in response to sentence indication. Of course, as an objective fact, it is not a plea entered at the earliest opportunity. I otherwise think that the utilitarian value in this plea remains largely unaffected by the fact it was entered after the provision of sentence indication. You have not run a committal hearing. Plainly, your plea has meant that there will be no trial. The family of Mr. Trover and the community have been spared the ordeal of a trial. I also accept that you have taken steps to resolve the matter early on, which further evidences a desire to facilitate the course of justice. Your counsel on your behalf rely upon two matters. Firstly, you offered to plead guilty on 22nd November 2024 to dangerous driving, causing death and failing to stop. The offer was rejected on 2nd December 2024 by the prosecution. It is unsurprising that this offer was rejected and the prosecution insisted upon manslaughter, given that you had intentionally and deliberately engaged in an unlawful and dangerous act causing Mr. Trover's death. That is, you deliberately struck Mr. Trover with the vehicle. Nevertheless, the offer you made bespeaks of an attempt to try and resolve the matter. Secondly, immediately upon this matter being listed in the Supreme Court, you sought a sentence indication. Also, this evidences some willingness to resolve the matter. There were also discussion at the plea about whether the fact that the plea of guilty was entered following the provision of a sentence indication affects the assessment of remorse attaching to a plea. In the end, I do not need to resolve this question in your case. This is because in your case, your counsel did not really seek to establish remorse upon the basis of your plea. Rather, your counsel primarily sought to establish remorse from other sources of evidence, most notably the medical material, which, as will become apparent shortly, I have largely accepted. It is convenient then to turn to examine the question of your remorse. The issue of your remorse is a mixed bag. As your counsel conceded from the moment you fled the crime scene, though to the moment you were arrested, you were absolutely remorseless. This is a quote from your counsel at the plea hearing, which I think accurately captures the state of affairs. You took a number of calculated steps in order to conceal your involvement in this crime. You took steps to conceal your vehicle at an acquaintance premises and remove components of the vehicle in an attempt to avoid detection. You did not come forward voluntarily. You then misled police about your possession of the vehicle. All this behavior post the offense must be seen as having been motivated by self-preservation. It showed complete disregard for Mr. Trover's welfare and dignity. It is acknowledged that your post-offending conduct is inconsistent with any acceptance of responsibility or remorse, at least during that period. When formally interviewed by police in May 2024, as it is indicated above, you initially lied about what had occurred, claiming that the collision with Mr. Trover was a mere accident. It was only after a break in the interview that you admitted to driving the street in hope of coming across Mr. Trover. You then made admissions. Your counsel made a number of submissions to the effect that the making of the admission was somewhat of a turning point for you. He submitted that after your arrest and after having made admissions to police, you ultimately obtained sobriety on remand. From this point onwards, you began to reflect meaningfully on your conduct in the process and with some psychological support. You commenced to develop some remorse with respect to your offending. It is not suggested that this transformation was either spontaneous or immediate. Rather, it has emerged through a process of enforced detoxification, counseling, and reflection. Your counsel placed reliance upon the medical reports. Dr. Steos stated that the following in his original report in relation to your remorse. Mr. Bench, that's the name of the accused, expressed remorse regarding his present offending. He appeared visibly depressed during the present assessment. He reflected on how his actions have had a significant impact, not only on his family, but also the victim family. His capacity for remorse appears genuine. Mr. Bench reported that he has experienced ongoing symptoms of depression and a trauma response as a result of taking another life. In the addendum report, Dr. Stas expressed the view that while you were in custody, that the offending had continued to dominate your thinking with recurrent intrusive flashback guilt and shame. Although you did not meet full diagnostic criteria at the time of his review, Dr. Stas concluded that you exhibited features of post-traumatic stress but did not meet the full diagnostic criteria. The Justice Health record that you were seeking trauma-related support while remanded and also reported low mood and anxiety. You reported nightmares as a result of the offending. You also engaged in several voluntarily psychology sessions with Dr. Brookstein for intervention related to trauma symptoms related to the offense. In this respect, you were prescribed medication to treat depression and anxiety while in custody. A letter of apology to Mr. Trover's family from you was also tendered at the sentence indication hearing. Reliance was also placed upon this as some evidence of remorse. Plainly enough, for a long period of time, you neither showed nor experienced any remorse of any kind. But I'm satisfied that you have come some way in developing real insight into your wrongdoing, and that you have been experiencing genuine grief and contribution what significantly delayed. Bespeaks remorse. You deserve a meaningful reduction for this. Remorse is also a factor which bears upon my assessment of your prospects of rehabilitation and some other matter to which I will turn in a moment. Prospects of rehabilitation. It was submitted by your counsel that you have some prospects of rehabilitation evidenced through a combination of number of factors, including the admission that you have made in your record of interview, the fact that you have now entered a plea of guilty, the evidence of remorse, your desire to reestablish relationship with your family, including your infant son. It has been argued that you have been every incentive to reform and to pursue a law-abiding life upon completing your present sentence. The ongoing support and commitment you have from your father, who can also provide stable accommodation. The fact that you have previously completed parole without incident. The commencement of your psychological treatment in custody and your willingness to engage in treatment to address your drug addiction issue. Again, against this, I must weigh the following factors. First, while the offending in this matter was not directly drug-related, the offending occurred during a period of instability in your life. The instability was compounded by your long-standing drug-seeking behavior and addictions. Your counsel submitted that when you were released from prison, you were initially sober and seemed to cope with being told about your parents' relationship with Mr. Trover. Sadly, your mother then died. This led to your recommencement of substance abuse. From there, your life unraveled. Tragically, this culminated with these events. I accept your counsel's submission that your rehabilitation to a large extent will turn upon your capacity to remain drug-free once you are released from the prison. As your counsel submitted, if you are substance-free, your prospects of rehabilitation are significantly increased. Given your history of drug abuse, there is some uncertainty about whether you can achieve this. The second factor, which tells against your prospects, is that unfortunately you have a number of prior convictions going back to approximately a decade. You've had many chances and have not taken them. Your criminal history culminated with armed robbery, for which you served a period of imprisonment. While you successfully completed the parole for that particular sentence, and even though the armed robbery is the only prior matter where you have been required to serve a significant period of imprisonment, the fact remains that this sentence did not deter you from committing the very serious offending which brings you before me. Overall, I accept your counsel's submission that you still have some genuine prospects of rehabilitation, which I'm somewhat guarded. There remains some legitimate room for reform. So much depends upon your attitude and your willingness and capacity to avoid falling back into a drug and negative peer milieu upon your eventual release. Your counsel urged me to make allowance for your rehabilitation, in particular in relation to the fixing of your non-parole period. Given my hopeful, albeit qualified findings with respectful to your rehabilitation and the fact that you're still relatively young man, I have endeavored to accommodate that request to some degree. Both parties referred to me a number of cases which they submitted were comparable or at least informed current sentencing standards. For many years, the authorities have recognized that the sentence range for the crime of manslaughter is strikingly wide, as in the range of criminal conduct that can cause the relevant unlawful killing. This means that much will turn upon the facts of each manslaughter case. And so it is here. The cases relied upon involved cases of manslaughter where the deceased was killed by a motor car collision and impact, usually with pedestrians. What marks your case out from these examples is that in your case, you drove at the deceased in a deliberate, calculated manner with the intention of striking him. This went beyond erratic or criminally negligent driving or driving aimed at merely scaring a pedestrian. This is one of the main reasons why it is that I have concluded that your manslaughter is such a serious example of manslaughter. Indeed, this central fact explains why it is that you fall to be sentenced for manslaughter by unlawful and dangerous act rather than manslaughter by criminal negligence. As a broad observation, what current sentences practices for manslaughter tend to show is that manslaughters falling in the higher range of manslaughter offenses following a plea of guilty tend to attract sentences into the low double figures. I turn to the question of totality. In fixing the sentences, I'm conscious of several matters. First, while I'm sentencing you for 2 offenses, I must ensure that the total sentence properly reflects your total criminality. I apply the principle of totality accordingly in my orders with respect to concurrency and cumulation. Secondly, I'm mindful that as you are to be separately punished for failing to stop a motor vehicle after an accident, I must not use this conduct to aggravate your manslaughter. I'm mindful of not double punishing you. Third, I consider that the failure to stop a motor vehicle after an accident constitutes serious and separate wrongdoing. The sentence for that particular offense must carry some weight in the overall sentencing outcome. This is achieved by accumulating part of that sentence upon the manslaughter. Now I return to where I began in these remarks. Notwithstanding the matters personal to you, Mr. Bench, you must be punished for your grave criminal wrongdoing. I'm conscious that my sentence cannot bring Mr. Trover back, but my sentence must carry the denunciation by the court of the conduct which you have engaged in, which involved the unlawful taking of a life. The principle of just punishment, general deterrence, and protection of the community all play a significant role in the sentencing task. While you have made progress with respect to remorse and rehabilitation, you still have some way to go. Specific deterrence must therefore also be given some weight. I must weigh all these considerations together with those matters personal to you which I have discussed. I turn now to sentence you. Please stand, Mr. Bench. In relation to charge 1, the offense of manslaughter, you are convicted and sentenced to 10 years imprisonment. This is the base sentence. In relation to charge 2, failure to stop after a motor vehicle accident, you are convicted and sentenced to 3 years imprisonment. I direct the 6 months of sentence imposed on charge 2 be served cumulatively upon the sentence imposed in charge 1. This results in a total effective sentence of 10 years and 6 months imprisonment. I fix a non-parole period of 7 years imprisonment. This means, Mr. Bench, that after serving 7 years imprisonment, you become eligible to apply to be released upon parole. Whether you are released on parole will be a matter solely for the parole board at that time. I declare that your pre-sentence detention, not including today, as 617 days, pursuant to Section 6AA of the Sentencing Act 1991, were it not for your pleas of guilty, I would have imposed a total effective sentence of 14 years imprisonment with a non-parole period of 10 years imprisonment. As you have been convicted of the offense of failing to stop where a person has been killed or suffered serious injury, then pursuant to Section 61, subsection 6, subsection A of the Road Safety Act 1986, the court must cancel all driver's license or permits held by you and disqualify you from obtaining any such license or permits for at least 4 years. I make that order. There's also a mandatory license cancellation and disqualification provision for manslaughter, which is defined as a serious motor vehicle offense by Section 87P, subsection A of the Sentencing Act, which requires the court to make a license cancellation and disqualification orders of not less than 24 months pursuant to Section 89, subsection 1 and subsection 2.